All right. Good afternoon, everybody. Thank you so much for joining us today. Welcome to this week's episode of the Martinez Law Legal Lounge. The point of these is just to grab lunch, sit back, and chat real estate. Hopefully, you have brought some wonderful questions for me to answer. I will be answering all questions live. So as those questions come up, just go ahead and throw them in the comments. No need to wait for me to ask for them to formally open things up for questions. As you have questions, go ahead and put those into the comments. I'll go ahead and just start by briefly introducing myself and the firm. My name is Kristen Martinez. I established Martinez Law back in 2015 as solely a real estate law firm. That's all we do is real estate law. We don't do any other type of law. We don't do title work. All we do is real estate law, and that's all we've ever done. So we are the experts in real estate law in the Tampa Bay area. So as you have questions, as you need service, please reach out to us. We would be so happy to help you out. Just as a little side note, if you want to go ahead and also include in the comments your name, what you do, and your contact information. Everything that we do, there's always an opportunity for networking. So if you want to leave that information in the comments, I'm sure that all of the viewers as well as myself would appreciate that, as well as your questions. So as we go throughout the episode today, I'll keep giving you a reminder to ask me those questions. That's the point of this. Maybe you don't want to call in for a formal consultation, or you don't think it's worth the lawyer's time to ask. That's what these sessions are for. I want to make myself available to you all to answer those questions that you have. So please leave those in the comments. And if you don't have any questions, please feel free to just say hello in the comments. I would love to see who all is here today. A couple of firm announcements I want to give to you. First of all, we have a YouTube channel. I don't know if many of you know that or not, but I wanted to make sure that you're aware because there's a lot of great content on there for you, especially as realtors, mortgage lenders, title company reps, anyone in the real estate industry really could benefit from that content. And we also record all of the events that I do and post those on our YouTube channel as well. So these events, these legal lounge events, are recorded. Our monthly Get Real events are recorded. Any presentations that I do, we'll go ahead and put on our YouTube channel as well. And we timestamp those. So if there's a certain topic that you're looking for or you're wondering about, you can check those out on our YouTube channel. So please be sure to check that out. Again, as you have questions, go ahead and drop those in the comments for me. I will be answering all of your questions live. I also wanted to remind you, we did officially announce a couple of weeks ago, but we are now taking in-person client meetings and new client consultations. And let me tell you, it has been awesome. I lean a little bit toward the introvert side, but these in-person meetings and new client consultations, they have been awesome. I realize how much we take that kind of personal relationship and that face-to-face relationship building with people for granted. And since offering those starting a couple of weeks ago, it's been really, really, really great. So if you have questions, if you're looking to schedule a consultation, I would love to see you in person. So make sure you give us a call and sign up for that. Again, as you have questions, make sure you are putting those in the comments for me. That's what I'm here for. I'm here to answer your questions live. If my audience is shy today and doesn't have any questions, I do have some questions that have come in through the office throughout the week that I kind of just put aside. I have my sticky notes here, and I save those so that everybody can get the benefit of those questions. So I have plenty to talk about, but I would love to answer your questions. That's what these are for. So again, as you join, please say hello in the comments. If you also want to drop your contact information and what you do, I'm sure others would love to network with you as well. Finally, our our monthly Get Real events are still going strong. June was the first month that we offered an in-person option, so we're still accommodating the Zoom option, but we do offer in-person options as well now. That is Get Real with Attorney Martinez. It happens the first Wednesday of every month. So our next event would be on July 7th at 10:30, and again, that's either in person or on Zoom. I'm going to go ahead and formally open up for questions from the audience. So as you have questions, like I said, please feel free to drop those in the comments. Not seeing any right now, I will go ahead and start with a question that I received this week and I think is very, very relevant given the current climate of the real estate market, or should I say the current craziness of the real estate market. And that is when we're talking the FAR bar contract, what happens if the buyer never puts the escrow deposit, the deposit into escrow? The buyer never pays the deposit. I have heard many agents and home buyers and sellers make the comment that, well, there's no contract, there's no enforceable contract if the buyer doesn't put the deposit into escrow. Um, not necessarily not necessarily true, not true at all. So in the legal theory that they cite is for a contract, you have to have consideration, and that deposit is the buyer's consideration. It's true to an extent. So the deposit is part of the buyer's consideration, but in any contract, and in the real estate contract specifically, the consideration are the mutual promises going back and forth. So the buyer's consideration is, I promise to purchase the property for this purchase price on this date. And the seller's consideration going the other way is, I promise to sell you the property, give you clear title, all of these things by the closing date. That is sufficient for consideration to create a binding and enforceable contract. So even if a buyer never deposits that initial deposit into escrow, there is still an enforceable contract, and at that point, the buyer is in breach of the contract, and the seller, if they so choose, can go ahead and move forward with the remedies that the contract provides for that breach. Jesse, thank you so much for joining today. I see you've left a comment here. Not a question for me, but I've seen a lot on the real estate boards about recourse when sellers try to get out of the contract. With multiple backup buyers, sellers are sometimes trying to back out, presumably to take a higher offer. This is an excellent point to bring up. It is also something that I do see a lot in this market. Sellers know it's a seller's market. A lot of times they are getting offers above asking price, or initially they're getting offers at asking price, and a new offer may come in above, or they may have a financed offer when, a couple weeks down the road, a cash offer is presented and they'd rather go that route. The bottom line is the seller in this example has signed a binding and enforceable contract. The seller does not have the option to just change their mind or to move forward with another buyer because the terms of that offer may be more favorable. The buyer's remedies under the contract are twofold. If the seller does walk and say, I'm canceling the contract, I'm not moving forward with you, I'm going to move forward with another buyer, the seller is in breach of the contract, and the buyer has two options. Off the bat, the buyer gets their escrow deposit back. That is not part of their damages or their compensation for the seller's default. That was their money to begin with. They get that money back. Their two options are, number one, they are entitled to any monetary damages that they have suffered as a result of the seller breaching the contract. So if they have paid for inspections, if they have paid for a survey or incurred any costs in connection with their loan application, all of those things, are direct monetary damages that the buyer has suffered as a result of the seller's default. The second option available to the buyer is to sue for what is called specific performance. That is an equitable remedy. Equitable just means a fairness remedy that is available specifically in real estate transactions. And it means that instead of asking a court or a judge or a jury to award you money damages, you're asking a court or judge or jury to force the other party to do something. In this case, it would be asking the court to force the seller to move forward with and perform under the contract and ultimately sell the property to that buyer. That is a remedy that is specific to real estate contracts. The reason being is that buyer will never be able to find the same exact property and the same exact location for the same exact price. They cannot make themselves whole by just going and buying another property. Real estate is unique, and you can't, as you all know, I'm sure, duplicate a piece of real estate. So those would be the buyer's options in that case. Thank you so much, Jesse, for bringing that up. Matt, thank you so much for checking in and saying hello. Um, as you guys have questions, make sure that you are putting them in the comments. I would love to answer them live for you here today. Not seeing any others at the moment, I will go ahead and give you a real life case example. And I first want to preface this with, and I always tell people, and I sometimes get eye rolls or I get shrugged off a little bit, but the absolute easiest way to prevent or avoid disputes down the road when it comes to real estate transactions is to make sure you've read the contract and you understand what it says. I know that sounds so basic and so simple, and of course, my clients read the contract, and of course they understand what it says. It's not rocket science. I get it. I agree with you. But it is crazy. It is shocking the number of people who are willing to sign contracts for probably the biggest purchase they're going to make in their lifetime without reading every word of it and without even understanding what the language says. Now, that's probably another topic for another time. Is it would behoove your clients to consult with a lawyer and have a lawyer go through and really explain how the contract works, the consequences if you violate the contract, those sorts of things. But just reading and making sure you're asking the right questions and understanding it will go such a long way in preventing disputes down the road. I have a case. I'm actually scheduled to go into mediation at 1 o'clock today on a case. And the reason why we are disputing, or why the parties are disputing with each other, is because the buyers did not understand the contract that they signed. In this case, both parties signed a crisp contract, which is different from the FAR bar, but it is, for purposes of this particular case, it is very similar to the standard FAR bar contract. It is not an as-is contract. So that means that as the buyer, you cannot cancel the contract because you change your mind or for any reason whatsoever, or because you decide there's maybe a different property you like better. There's not that option in this contract. And it became very clear very early on that the buyers didn't realize this. They attempted to cancel the contract, ended up not going forward with the contract, and now are being sued because they didn't understand what they were signing on day one. Had they understood it, maybe they wouldn't have signed that contract. Maybe they would have made an offer on the as-is version of the contract, but they didn't, and I don't think that was intentional. I think it was because they either didn't read or didn't understand how the contract works in that situation. So that is the best tip that I can give agents and home buyers and sellers, is make sure that you are reading the contract, you understand what it says. If you don't, make sure you're asking questions. Real estate is not your business. You're not expected to know every little thing under the contract. I would venture to say that most agents and most lawyers don't know every single word under the contract and what it means and how it would play out if you went to court on any particular issue. So ask the questions, and as agents, make sure that you're clients are taking the time to read through and understand, or at a minimum, you're just advising them to. At the end of the day, you want to make sure that you've done everything you can to help your clients. You can't force them to read it. You can't force them to understand it or to hire an attorney to review the contract with them. But you can advise them that that is the best practice and that is the number one way that they can protect themselves and avoid any disputes down the road. All right. Thank you, Elvira, for checking in. Jesse, thank you so much again for bringing up that issue. As you have questions, make sure that you are leaving those in the comments. I would love to answer those live for you today. We are nearing the end of our time, but again, as you have questions, please make sure you are leaving them down in the comments. If you could also like this video and go ahead and share it. Like I mentioned earlier at the beginning of the episode, we will be recording and time stamping this episode and posting it on our YouTube channel. So if you've missed it, if there's a piece of it that you want to go back and reference down the road, make sure you do that. If you do have questions or a potential dispute or contract issue that you are dealing with that needs a little bit more time and attention than I can give on these Facebook Live sessions, make sure to contact our office. Our office number is 813-803-4887, and I will go ahead and leave that in the comments as well. If you need to go ahead and schedule a consultation with me or our other attorney, Tiffany Love McElherron, who is also an expert in all things real estate. We would love to assist you and help you out with that. All right, last call for questions. Any other questions for me? As the week goes on, I hope you have a wonderful week, but also as questions come up, as your clients ask you questions, even if they don't need immediate attention right now, jot them down. You don't know who else they could, that those answers could be helping. You don't know when that situation will come up again for you in the future. We will answer them live. We will record the sessions, post them to our YouTube page for you to have as a reference. There's a lot of other great content on all of our social media pages, so make sure you are checking that out. And again, if you could like and share this video, that would be greatly appreciated. Have an awesome week. I will see you next Monday, same time, same place for the Martinez Law Legal Lounge.